Priority, sales, and closing mechanics. Hello again, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second major issue, priority sales and closing mechanics. The convention's core priority rule is in Article 29. A registered interest has priority over any other interest subsequently registered and over an unregistered interest. It does so even if the first filer had actual knowledge of the other interest. This is the treaty's great commercial simplification. For eligible aircraft objects, priority is built around registration timing, not around sympathy, not around assumptions, not around who complains the loudest after closing. For buyers, the aircraft protocol adds another critical rule. Under Article 24, a buyer under a registered sale has priority over subsequent registered interests and from unregistered interests, even if the buyer had actual knowledge of the unregistered interest. That is why sale registration can be more than a nice extra. In the right transaction, it provides a measure of title protection. There is also an engine-specific point that deserves emphasis. The aircraft protocol states that ownership or another right or interest in an aircraft engine is not affected by its installation or removal from the aircraft. That matters enormously in business aviation, where engines can be swapped, financed separately, leased separately, or become the subject of separate disputes. If counsel ignores the engine analysis, counsel may be protecting only half of the asset picture. In the United States, there is an additional procedural layer. The FAA Civil Aviation Registry is the United States entry point for eligible U.S. civil aircraft. Aircraft assigned a U.S. registration number and qualifying engines. Under 14 CFR Section 49.63, a party seeking a unique authorization code must file AC Form 8050-135 and, for a U.S. civil aircraft or engine, file the related transaction documents with the FAA Aircraft Registry. The FAA reviews the form for completeness and returns a unique authorization code for use at the International Registry. The FAA expressly says that acceptance of the form does not mean the agency agrees with the filer's representations. The procedural details matter in practice. A lawyer can have a flawless deal document and lose priority if the registration steps are late, incomplete, or missequenced. The closing checklist must therefore identify the aircraft object, confirm eligibility, obtain the entry port authorization when required, complete the electronic registration correctly, secure the required consents, and confirm that the registration actually appears in the International Registry in the correct order. Another practical lesson comes from the Blue Sky One and Mahan Air litigation in England, which is often discussed in aviation finance circles because it exposed how aircraft title disputes can be multinational, document intensive, and brutally expensive when sale and financing structures unravel. Whatever one thinks of the specific holdings, the commercial lesson is pretty clear. Aircraft title and property disputes do not stay tidy once the asset, the parties, and the jurisdiction begins to move in different directions. That is one reason prospective registrations can be so valuable. The FAA specifically provides a process for prospective interests affecting eligible U.S. aircraft and engines. In a financed acquisition, filing a prospective international interest before the final funding event can preserve the position while the parties complete the closing mechanics. In a world where wires can be delayed and signatures can arrive out of sequence, it's just more than administrative convenience. It's risk management. Another point is often missed by owner clients. Registration strategy is not only about lenders, it's about purchasers, agreements, trusts, agency structures, and representative capacities. The aircraft protocol allows persons acting as an agent or agency, trust, or other representative capacity to enter into registered interests in aircraft objects. So where the aircraft are held in owner trusts or special purpose entities, the registration analysis must match the actual transaction architecture. Here is something to remember. On the International Registry, priority belongs to the disciplined. The closing discipline, therefore, should be uncompromising. Match the serial number on the purchase agreement, bill of sale, security agreement, lease, FAA Entry Point filing, and International Registry registration. Confirm who must consent electronically. Confirm whether the transaction is a sale, a lease, a security interest, or more than one of those. Confirm whether separate engine registrations are needed, and confirm the discharge path for any prior registrations before money is released. The bottom line is simple. The International Registry rewards the prepared and punishes casual closing practices. In private aviation, where aircraft regularly cross state and national borders and where ownership structures can be layered, that priority discipline is not optional. Thank you very much for your interest in this topic. This information is provided for informational purposes only. It should not be construed as legal advice. Please direct questions, which are always welcome, to admin@aviationlegalcounsel.com. We look forward to helping you navigate your aviation-related legal needs with precision.